Well, hi everybody, welcome. Today we are going to be talking about a number of different topics pertaining to associations, and I appreciate you coming out on a Wednesday morning to learn more about your associations. Just a little bit of background on myself. My name is Beth Mulcahy, and I'm an attorney that has been practicing in the area of representing associations for the past 23 years. This is all I've done in my legal career, and my firm currently represents about 1,500 associations throughout the state. So I have a lot of experience in working with a number of different boards for a long period of time. I also have served on my board. I'm currently the president of my association, and I also serve as a director at large for one of the sub-associations that I live in. So I have a unique perspective that I bring here today. And I also had just a little jaunt where I was a disgruntled owner where I wasn't on the board. So I think I pretty much do the full circle here of all different roles with associations. Before we get started, I would like to find out who my audience is, because I always like to know, if we have a lot of board members or we have a lot of homeowners. So just a show of hands, how many of you are board members in your association? Okay, excellent. And how many of you are homeowners in your association who are not board members? Excellent. So of those of you who just raised your hand that you're homeowners not currently serving on your board, how many of you are dissatisfied with how your board is running? Okay. And then the last question is, of those who are homeowners who are not currently serving on your board, how many of you would be willing to step up and serve on your board? Okay, that's encouraging number. So just a little background information. For those of you who are owners who are here today, who are unhappy with how things may be running at your association, recognize that that is how a great majority of people get on their board. So know that. It's because you're dissatisfied with the status quo. And so you want to make sure that it's great that you're here today, because we're going to be talking about a number of different issues. We're going to be talking about the new legislation. Our legislature just closed a couple of weeks ago. And we're going to be talking about how to be successful as an association. And I can tell you from just being in the trenches for over 20 years, it's hard. It's very, very difficult to have a successful association. I would be lying to you if I said, oh, this is so simple. This is the easiest thing, that every board is successful. It's not, because there's a lot of different things going on. There's a lot of different skill sets that you need to have to be successful as a board. Well, first you need to understand how to run a business, right? The financial side of running a business. And then you also have to be really effective at the people side of business. And from what I've found in my experience of working with associations, the hardest part of running an association is the people side. It's getting along with a wide variety of people and having everybody move in the same direction at the same time. That's the hardest thing to do as a board. So I'm going to give you some great suggestions today on how to be successful. What's the secret recipe so that your association can be successful in your dealings with your owners and work together. That's the most important thing. Okay, so we're going to start out with the new legislation regarding associations. And I have with me here a little handout that I gave everybody, and we have extra handouts. I think everybody should have some now. We have some at the front too. And it looks like we're going to have some extras at the end of today too. So if any of you want to take some back for your boards, you're welcome to do that. Or if you want to call my office, we'll mail them to you too, okay? Well, first let's talk about our legislature. So every year our legislature has passed new legislation pertaining to associations. For as long as I've been practicing law, since 1996. And so every year we have more regulations that we need to be aware of and that we need to follow as a board. And this year was an especially busy year in the legislature regarding associations. And we're going to be talking about the new bills and what they mean for associations and what your associations need to do so that you make sure that you comply with the new legislation. So what I'm going to be referencing is, this is our quick summary of the new bills. This is just the listing of the names. But I'm going to be going through in depth this handout that everybody should have. And it says at the top, 2019 pending bills summary. So the first thing that I want to talk about is there's a bill called Senate Bill 1094. And this bill probably isn't going to apply to a lot of associations in surprise, but there's a very interesting backstory on this bill. That it's like, you know, I'm from Wisconsin, I grew up in Wisconsin, and you know, I could see from the bedroom window that I grew up in the Usinger sausage factory. And people always say, watching a sausage get made is very interesting because there's a lot of different things that go into it. It tastes good at the end, but there's a lot of different things that go into it. And that's kind of how legislation works. There's always a backstory. If you're really involved in our industry and you're following legislation from year to year and you're seeing how these bills evolve during each legislative session, you'll find out that there are some great juicy scoops on how these bills become law and what they really mean. And this first one is fascinating. So this is the first time I've ever seen a case or a new piece of legislation that is in direct response to a lawsuit that has occurred in Arizona, okay? And so some of you may be aware that there was a lawsuit regarding Sun City. Do we even have any people from Sun City here today? A couple, okay, so you may not even be aware of this, or you may be.
I'm aware of the lawsuit.
You're aware, okay. So there was a lawsuit in Sun City where a judge, some homeowners wanted Sun City to be subject to the Planned Communities Act. And as you know, in Arizona, if you're a condominium or a planned community, there are certain laws that apply to you. And the Planned Communities Act is a law that applies to planned communities in Arizona. But there's a specific definition as to if you're a planned community, you have to fall under the definition as outlined by the Planned Communities Act. And so there has been a belief over the years that Sun City West, the master organizations, that those particular associations are not planned communities. That was always the belief, and therefore are not subject to the many stringent requirements of these laws, the Planned Communities Act, such as open meetings and notice of meetings and owners being able to make records requests to find out more information about their association. So what happened is some owners sued the association Sun City, and it was determined that by the judge that Sun City was subject to the Planned Communities Act, okay? And so the judge made their decision, and then in response, we saw this legislation get passed this year. And like I said, it's very unusual but interesting that, you know, a lobbyist would take on this cause and try to pass a bill that would effectively try to overturn the results of litigation. So it's fascinating. This is the kind of geeky, wonky stuff that I love. So, okay, let's look at Senate Bill 1094. This was signed by our governor on May 17th, 2019. And many of these bills are not going to go into effect until 90 days after our legislature closed. So we're looking at a late August, early September effective date of these bills. So the first bill, again, Senate Bill 1094. This bill is going to remove the applicability of the Planned Community Act for a nonprofit corporation or unincorporated association of owners that is created or incorporated before January 1st, 1974, and that does not have the authority to enforce covenants, conditions, and restrictions related to the use, occupancy, or appearance of separately owned lots, parcels, or units in real estate development, unless a majority of all the members of the nonprofit corporation or unincorporated association of owners elect in writing to subject the association to this chapter by recording a notice of election pursuant to this chapter. So basically what this is saying, and this is going to apply to Sun City, is that any association that was created before January 1st, 1974. That's the first, little hoop they got to jump through. And they can't have authority to enforce the covenants. Okay, so They don't have the authority in their governing documents to handle enforcement of the documents. That's the second tier. If you're one of those associations that's incorporated before or unincorporated before January 1st, 1974, and you don't have the authority to enforce the covenants, the only way that you can be subject to the Planned Communities Act is if you have a majority of all the members approved for you to be subject to that. Okay, Senate Bill 1309. This just talks about renewal of judgments. And how this will apply to associations is if you obtain a monetary judgment against an owner for, let's say, not paying assessments or not paying fines or attorney's fees and costs that may have been incurred in a case, you have to renew that judgment now every 10 years. And it's a further clarification of a new law that went into effect last year. So just so you know, if you get a judgment, your attorney should be keeping an eye on that. That's part of their job. If you get a judgment against an owner and the owner doesn't pay it, you have to renew it 10 years from the date that the judge signs it. Otherwise, it becomes invalid. So obviously, if the owner pays it before then you release the judgment or you satisfy the judgment and it's over. But if you have a long-standing judgment that's unpaid, then you have to renew it in order for it to be valid every 10 years. Okay, now we're on page 2 of the new legislation. This bill is Senate Bill 1531, and this bill will apply to every planned community and condominium in Arizona right now. And this is something that you definitely need to have on your radar by early September, and make sure that your association is fully complying with this if you're an association that needs to comply with the Condominium Act or the Planned Communities Act. And basically what this law does is it makes some mandatory information to be included when we're contacting owners regarding delinquent assessments. And it's really a protection bill for owners so that they understand if you don't pay your assessments, this matter will be turned over to the attorney. And so the first part of the law is, it's interesting, whenever you see new legislation, sometimes the legislature tries to make it a win-win. So the first thing that they did is they extended the time period that we can enforce a lien against an owner from 3 years to 6 years. And the impact of that is, right now, the way that the law reads until this new law goes into effect this fall, is that we can, if we're going to foreclose on an owner, we can only go back 3 years from the date that we file the foreclosure. So let's give an example. So June 5th, 3 years back to June 5th, 2016. We can only go 3 years back as part of the foreclosure lawsuit. If they owe more than 3 years, we have to do a separate claim, a personal judgment claim against the owner. That's typically a little bit harder to enforce than the foreclosure. The foreclosure is where we would actually ask the court to intervene and sell the property. And the property either go back to the association or be sold to a third party, and then the association is paid in full. So the good part of the law is that now we have 6 years back. We can go 6 years back to enforce foreclosure liens against an owner. So that's a positive for associations. The flip side of this, whenever they try to make it a win-win bill, is that it also places some restrictions on associations that they have to notify their owners of certain language. And the implication of the language is we have to tell owners, hey, your file is going to be turned over to the attorney. And so what the law says is for any time an association has a delinquent account for unpaid assessments or charges related to the unpaid assessment, such as late fees, legal fees, interest, costs related to the attorney's fees, the association has to provide a written notice to the owner. Okay, so the written notice has to be sent to the owner at the owner's address provided to the association at least 30 days before authorizing an attorney or a collection agency to begin collection action on the association. And so the notice has to say this language that I have bolded right here. So your account is delinquent. If you do not bring your account current or make arrangements that are approved by the association to bring your account current within 30 days after the date of this notice, your account will be turned over for further collection proceedings. Such collection proceedings could include bringing a foreclosure action against your property. And they're very specific in terms of how this language needs to be set up. You have to use this exact language. It has to be bold-faced or in all capital letters, and must include the contact information for the person the owner can contact to discuss payment. And this notice has to be sent certified mail, which is an extra expense for associations, return receipt requested, and may be included with other correspondence sent to the owner regarding the owner's delinquent account. Beginning January 1st, 2020, except for condominiums, planned communities that have less than 50 units or lots and does not contract with a third party for management services, the association shall provide a statement of account in lieu of a periodic payment book to the member with the same frequency that the assessments are provided for in the declaration. So this language is going to need to be in the letters starting, when the effective date of this new legislation is, which is going to be early September. But then beginning January 1st, if you're an association that has more than 50 or more lots or units, and if you have a management company, you have to provide a statement of account, not a periodic payment booklet. So there's a difference. A statement of account is going to show all the charges and the balance. A coupon book is different. That's what a lot of associations have been doing in the past. A coupon book just has the coupon for that month. And I think the reasoning on this is that the legislature is concerned that owners don't know how much they actually owe. The coupon book just shows how much the assessment is for each month in that year. But now, if you're an association that has 50 or more lots or units, and you have a management company, you're going to have to actually send the statement. But that won't go into effect until January 1st, 2020. So we have a couple extra months to implement that. And that kind of makes sense because most of us do the new coupon books in January, right, for that year. So they want to make sure that you're setting it up for 2020 in the proper way. The statement of account that's required under this new law must include the current balance due and immediately preceding ledger history. So it's going to have a breakdown of how much is owed for each lot or unit. The association can stop providing further statements to the member if collection activity begins regarding that member's unpaid assessment amount. So I'll come back as soon as I finish it, okay? Any request by an owner for a statement of account after collection activity begins by an attorney or a collection agency must be fulfilled by the attorney or the collection agency. So let's just do a quick recap because this is probably the most important bill we're going to talk about today. So the first thing that we need to recap is we now have 6 years to enforce liens, effective, the effective date of this new legislation, starting in early September, which is a good thing. Kind of the more difficult part of this law is that starting the effective date of this new legislation, which is going to be early September 2019, anytime the association sends a notice to your owner regarding delinquent assessments, you have to have this language in boldface in that communication. And it has to either be boldface or all caps. And the notice needs to be sent by certified mail, return receipt requested. And then remember the second part of this law, which is an additional requirement as of January 1st, 2020. If your association has 50 or more lots or units and you have a management company, you are required to provide a statement of account, not a coupon book anymore. Now, of course, some associations, I know I'm going to get this question. This is actually the first class I've taught on the new legislation, but I'll be teaching probably 100 before the end of the year. If you choose to also send a coupon book, that's your choice. The law doesn't prohibit you from sending the coupon book if that's been your procedure and that's working for your association. But in addition to the coupon book, you're going to need to send that statement of account to comply with the new legislation. Okay, let's switch gears. We have 2 more topics. We knew that the new legislation was going to be our hot topic today, and we were going to spend a majority of the time on that. However, I do want to spend the last time that we have here today, talking a little bit about what are some important things that are some case law that's important, and also we wanted to give you a little handout on preventing crime and limiting liability. So I'm going to start out with this. I don't have this as part of the PowerPoint, but this is just kind of a good little handout that I would like all of you to take a look at. If your association has any incidences of crime or break-ins or car theft or things of that nature, this is a really good little handout that we have distributed many times on how to prevent crime and limit the liability of your association. So I would encourage you to take a look at that. And we're going to be talking a little bit about one of the cases here today in response to this. So why is case law important? We started out talking a little bit about the new legislation and why the legislation is important. It trumps many of our documents, as I answered for one of the owners here today. And the legislature is giving boards guidance on how you should be operating your association. So case law is different in that there's an actual dispute between an association and an owner. And in my 23 years of practicing law, I can tell you unequivocally that Arizona has a very limited number of cases regarding associations. And there's a couple of reasons for that. Well, first, really, our Planned Communities Act and our Condominium Act didn't even start until 1986. So we haven't been around as long as California, New York, Florida, where they have been having associations since the 60s. But also, a lot of disputes get resolved before something gets to an appellate case. And so, maybe there's a maximum of 10 important cases in Arizona. And in comparison, like in California, there's 300, 400, 500 cases that you really do need to know about if you're going to be, on your board or representing associations. So we have limited case law. But what I'm going to do today is it kind of gives us, the importance of this is that the appellate court is giving us direction on an issue. And so we use these cases as instruction so that your boards can make good decisions. Very rarely will you have the same fact pattern as these cases because every association has different CCRs. We have a different cast of characters who live in the association. But these are instructive as to how we can best manage running our association. So the first case is the Garden Lakes case. I just referenced this really, in the beginning of the presentation, and I have the PowerPoint just so everybody knows on the handout as well. So in the Garden Lakes case, this case was about solar energy devices in an association. And really the bottom line on this case, and actually this was my case, this case went all the way up to the Court of Appeals in the year of 2000. So I was a young lawyer when I was trying this case. And it went to a trial court, and then it went to the Court of Appeals, and then it stopped at the Arizona Supreme Court. And basically what happened in this case is that we had two owners that put up solar energy devices on the roofs of their homes, and they didn't ask for permission before they did it. They just put it up. And the CCRs for this particular association, it's an association in Avondale, they said that any exterior modification to the home needed to have approval of the architectural committee. And so these homeowners, as principal, decided that they were not going to ever ask for permission because they felt that under the law that the association couldn't do anything to effectively prohibit solar energy, so why should they have to ask for permission? So like any case, this case was actually a fascinating factual case. About 3 days before trial, a co-defendant in the case died, Mr. Madigan. And so we were left going to trial against the Speaks. And basically what the court in this case said was, yes, the Speaks were wrong for not getting approval prior to putting up the solar energy devices, but had they gone through the proper procedure, it would have been approved. What they did could not have been disapproved. And so it's kind of an interesting take on this. And kind of my key takeaway on this case is that when you have an owner who does something on their property, like let's say they paint their house a new color or they put in a gazebo in the back that's visible from the street, if your architectural committee would approve it had they gone through the regular normal channels, this probably isn't a case you want to pursue, right? Because ultimately the court's going to, go to them for not getting approval, but ultimately the case is going to be about would this be approved if they had gone through the proper channels. So that's kind of an interesting, take on this. But the bottom line in the case is, in this case, they gave us some additional factors to look at when we're evaluating solar panel installations on properties. And really the solar panel installations are only going to apply to a planned community, because right now the law in Arizona doesn't support an owner putting solar energy devices on common areas in a condo for their personal use. So you couldn't go and put solar panels up on your condo roof because you don't own that. You could only go and put solar panels up on something that you actually own, like in a property in a planned community. So there's a number of different things that you should be looking at if an owner wants to put solar on their property. I'm a bottom line kind of person. The bottom line is that it's almost impossible to tell someone they cannot have solar on area that they own, a property that they own. And if you're thinking about denying an application in a planned community for an owner to put solar on their property, get your legal team involved and get advice, because you're probably going to lose. They're very tough. Arizona is for the free use and enjoyment of solar. And so I think this case kind of has those two, takeaways for me as an attorney practicing in this area. Let's see, the next case is the Johnson versus the Point case. This actually was my case too. I think myself and one other attorney in Arizona, I think we have the most reported decisions right now, and that could change. I'm getting older, I'm 49, so we may have some younger people coming up too. But in this case, this was such a fascinating case. I could have a whole class on this case. So Mr. Johnson was actually on the board in this case, and he sued the association because he was upset that his neighbor had changed the wall in the backyard of their home from rough stucco to smooth stucco. And so very petty facts. He was on the board, he's suing his own association, and it's a very small area. So the area where the stucco was changed, it was not the entire home. It was an area right above a grill. So think about this. I've been to the property for property inspections multiple times in this case. So let's say the grill area, it's probably about as big as this. Just lift this up and then have, the grill area right underneath it. And so interesting, fascinating case. We won in the trial court. Judge Pendleton Gaines looked at this case and he said, "Are you kidding me? Why are we here?" And he said, I do not find this to be a modification that needed the architectural committee's approval, and association, you win. Well, Mr. Johnson, he's going to take it to the Court of Appeals. And the Court of Appeals said, well, wait a minute here. The CCRs say any exterior modification needs architectural approval. So we're going to send it back to the trial court to determine whether the architectural committee actually did a formal review. So after the Court of Appeals ruled in that way, we had the owner submit an application after the fact. Again, interesting to note that the court isn't upset that they're doing it after the modification. Second case I've seen that in. And I used the Garden Lakes case in my little factoid of information to help me win this case. Oops, I was telling you in advance. Okay, so we take it back. The architectural committee approves the smooth stucco, and we have a trial, right? Jury trial, Superior Court. And this is in 2003. And actually, this is 2004, because the Court of Appeals decision was in 2003. So we get in front of a jury, and we had another great judge. Both of these judges are deceased now, but we had another judge, we used to call him Stormin Norman. I can't remember, Norman Hall was his name. Anyways, so the jury, usually when you're in a jury trial, you're looking at the jury for, like, how do you feel about the case, right? And sometimes I'll go down and watch my husband when he's in court, and I'll tell him, yeah, that juror doesn't like you, or be nicer, So I'm sitting there, I'm trying the case. I have co-counsel who's representing the Boyles, who were the homeowners that did the grill installation. And the jury is looking at Mr. Johnson's lawyer, and they're openly hostile. Okay, they're shaking their heads. I mean, it's bad. So we go back in chambers with Storm and Norman, and he says, you know, Barry, who is the other lawyer's name on the other side, he goes, "This isn't going well for you." And, you know, you should be talking about settlement. So he didn't listen. We have a week trial, a week and a day trial, and the jury comes back and they say, yeah. Oh, and I forgot, I left one huge fact out of this that's so fun. So about a week before the trial starts, cat's claw had grown all around the smooth stucco. It actually looked really pretty, right? So we got all this greenery, and so the Boyles lived in Pennsylvania. They were not here yet. And one of the other board members lived in this, all the houses kind of faced each other, and she caught on video Mr. Johnson jumping the fence, going over, tearing down the cat's claw, okay, and then jumping back over, okay? And so the big issue the first day of the trial was, does the jury see this, right? Prior bad acts. It got in. And that was, like, when that happened, I mean, there was like one juror, they had these little notebooks. He took the notebook and he got, bam! Like, it was like they almost did a mistrial over it, because it showed that this person maybe couldn't be impartial anymore. So anyways, the jury comes back, surprise, surprise, the point wins. We got all of our attorney's fees, and surprisingly, it was over $350,000. Mr. Johnson had to pay it, and he paid it. So the bottom line here is, don't be too nitpicky, right? And also remember that if somebody doesn't do an application before they make the modification, you can always go back after the fact and have them do the modification to dot your I's and cross your T's. Okay, Martinez versus Woodmar. This kind of goes hand in hand with this blue, preventing crime and limiting liability for associations. So this is a really interesting case where an association was held liable, had legal liability for a shooting that occurred on the property. And in this particular case, this association is in Maryville, and the association knew it had a history of crime and gang activity within the association. And because of financial reasons, the association made a decision to lower the amount of security hours for the security guards. So they knew they had a problem, gang problem, and for financial reasons, they said, we gotta just lower, we don't have enough money to pay the security guards. And so after that happened, a guest of a tenant, imagine that, a guest of a tenant in an association is shot in the parking lot, and the guest of the tenant sues the association for failure to provide adequate security in the association. Interestingly, the Arizona Supreme Court, you know, all these courts they fight, they felt that the Arizona Court of Appeals mischaracterized the case, blah, 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 you know, it's drama. Ultimately, the court found that the association should be held to the same standard as a landlord, and that we have a legal obligation as an association to keep the common areas safe and free from crime. So talk about a chilling effect case. That means that if you are aware of crime or, you know, potential dangerous activities that are occurring on your common areas, you have a legal obligation to take steps to remedy that. You know, so let's say that you had, like, where they made the mistake here in this case, this board, is that they had the security guard, right? And instead of increasing it or keeping it where it was, they lowered it, they dropped it. And when they didn't have any security, that's when the shooting took place, and it opened the door for liability. Now, of course, we all have D&O insurance for our associations, or I hope you have directors and officers insurance. If anything like this should happen, you know, you would have coverage for something like this to defend your association. But this type of case could be the type of thing that could exceed your coverage, and then it goes into your financial coffers of whatever money you have in your association. So key takeaway here is, if you know you've got potentially a dangerous condition on your property and you don't do anything to rectify it, you could have liability. And this could, you know, have a chilling effect in terms of raised sidewalks, other dangerous things potentially dangerous things on your property. If you do nothing about it and you're aware of it, there could be liability. Okay, let's finish up with what's the secret sauce? What are my tips from how your association can have secret tips to get a successful association? So it really depends on a number of different things, as to how your association can be successful. But probably the underlying thing is strong and effective leadership, I think is the underlying most important backbone here by an entire board. Communicating well with your owners, complying with your governing documents, having an outstanding team to go with you along the way, whether it's your management company, your attorney, your insurance professionals, your reserve specialists, just surrounding yourselves with an A-team to help support you. And so let's just go through the most important things first. Oh, wait, one more thing that I'm going to add to this cheat sheet now that I've been serving a hard time as a president of my association. I'm going to add something about when you make a mistake, acknowledge it, fix it, apologize. The worst thing that can happen is when an association, and you're going to make mistakes, right? We did not spend the last years of our, whatever our careers were, or the last 50 years of our life getting ready to be on the volunteer board, right? No. So, and I'm only telling you this because my board made a mistake and I'm the leader. So even me with all my experience, I make mistakes too, okay? So acknowledge the mistake, address the mistake, apologize. Secret sauce. Okay, let's talk about what are some traits that I see for the most successful associations. The best associations communicate. Often, early, communicate especially more in times of crisis. Making sure that the owners know what's going on so that when you have naysayers, and let me tell you, you're gonna have naysayers, right? That's the nature of this game. That when the naysayers go around and try to spread misinformation, guess what? They're not going to listen because they're going to say, well, that's not what the newsletter said. And I saw the board members, at the board meeting, and that's not what they said. But if you're a board that keeps everything under wraps and makes decisions in secret rooms, the naysayers, that's like oxygen to them, right? So be a good communicator as your association board, and you will have fewer hassles. What are some ways to be a good communicator? Give members an opportunity to speak or ask questions for a set period of time at the beginning of each meeting. Distribute or publish mail notices of board meetings, meeting minutes, or financial statements to owners regularly. You're not hiding anything. We want people to be informed as to what's going on. Have a town hall meeting, especially if you have an issue that's highly controversial, where owners can submit questions for the board to answer, or the board can meet with residents in an informal Q&A setting too. 4, plan and present social events around holidays where board members can interact with neighbors in a relaxed environment. 5, respond to member inquiries in a timely fashion. And if managed by a management company, ask the manager to respond within a time period. The worst thing you can do is blow off owners, not respond to their records requests, and sometimes as a board, you don't know that your management company is doing this, right? So if you're hearing feedback from your owners, the management company never responded to me, or that's where we really need to acknowledge, change course and apologize. Tell the management company what your expectations are as a board. You need to respond to emails. You need to respond to people who contact you by phone and give them the time period to do that. Give owners the name and telephone number of a contact person for the association so they feel that they can call somebody if they have a problem or a question. Have surveys done so you can get input about how people feel about your association. Form member advisory committees and consider their input. Sometimes if you have people that are really negative about an issue or very vocal, maybe give them a job, right? Put them on an advisory committee. Ask them to do a recommendation or do research and recommend what changes you want. Form a welcome to the neighborhood committee and have a welcome something for the new members that move into your association. Have a website, post newsletters, meeting minutes, budgets, annual reports, any association information on there so that people have a place that they can go to look if they have questions about your association. And another thing that some associations do is give members a self-addressed and stamped postcard or a comment card annually so they can give us feedback, because like this gentleman said over here, we don't usually get a lot of people that come to meetings. And I will say from my experience that if you don't have high participation, it does probably mean things are going really well. When I walk into a board meeting and there's 100 people there, I'm thinking to myself, I'm not saying it, but I'm thinking to myself, there's some dysfunction here. What's going on? And so if you don't have a lot of people coming, that means that most people are generally very happy with how things are going. And that may not be a bad thing, that you don't have a lot of participation. Have strong leadership in a community association. So much like a sports team or a business leadership team, we have to have, leadership from the top. So how can you show strong leadership? Here are some good qualities of your leaders. So emphasize teamwork. Your board can achieve success by acting as a team. You might even want to consider having a team building exercise or a social event where you don't discuss association business to try to bond your team together to work better together. Look at what people's strengths are and have them working in that capacity on the board. Like my board, where I live right now, last year we had our president was very strong on technical skills like financials, strategic planning, but he was horrible on bedside manner. And so it was not a good role for that person to be the president because, let's face it, the president has to be nice, right? And you have to listen, and you have to, empathize and say, I'm sorry. And, that was not something in that person's skill set. So when I became the president this year, I put him on strategic planning, a 5-year plan, reserve study, finances, and he's excelling at that, and he's so much happier. We almost lost him as a board member, and he has such a great skill set. So really think about what people's strengths are, and try to place them in the right position on your board. Honesty, integrity, and transparency. If your owners don't think you're telling them the truth, if your owners think that you are making decisions that are not in the best interest of the association, and if your owners think you're hiding things, it's going to be horrible. You're going to have the worst experience of your life serving on your board. So just remember, tell them the truth, even though it hurts sometimes, just lay it out on the table. It's better to just, we made a mistake, or this was an error on our part, we're sorry, here's what we've done to correct it. Transparency, don't be hiding things, don't be making decisions behind closed doors. Try to do as much as possible out in the open. If you have a problem, like I hate to say this, but on my board right now, we have 2 problem board members. We may need to have a code of conduct for our association. And I have a sample one we have 55 of these wonderful cheat sheets on our website. One of them is called the Code of Conduct. And that may be for somebody who is spreading misinformation or who is causing a lot of problems for your board. Or maybe even making decisions that benefit them financially, individually. The code of conduct can address all of that, but the hard thing is you got to get them to sign it. Commitment, but one thing you can do is you can shame them for not signing it. We had to do that on our board. Everybody on the board but the 2 signed it, right? And so we just said in an open meeting, this is the situation. We have a 10-member board, and we have 8 out of the 10 that agreed to the terms of the code of conduct. 2 are refusing. And people in the crowd, they got it. They got it right away. Well, why aren't they signing that? So, okay, commitment and determination. This is the hard one, even for me in my association. So you have to be committed to sticking it out, and you got to be determined to getting things done. It's not easy. And for those of you who are homeowners here today, I know it's 2-to-1, homeowners versus board members. Let me tell you, it is not easy being on the board. It is the worst job ever, okay? I hate to say that because some of you are thinking about getting on the board, but cut some slack for the board members. They're volunteers, right? Some of these people have already had their whole business life behind them. They're injecting themselves into problems. You know, they thought they left that in the rearview mirror, but they're willing to step up to help. And so give them a little bit of, credit for serving. And while you may not agree with them, be nice, be respectful. It's okay to say, hey, I don't agree with how you handled that, but I really do appreciate you volunteering your time. But personal attacks, harassing emails to board members, that is not acceptable. And board members don't have to take it. Okay, in terms of board members, remember, it's not a life sentence, right? You only agree for a certain period of time, and just try your best to do your best while you're serving in your capacity as a board member. And I know when I started this year with my agenda as president, I had, I thought I could accomplish a lot more than it looks like I'm actually going to be able to accomplish. Just savor the victories, savor the things that you are able to accomplish, and then try to set the path for the next president, maybe to continue on with some of the things that you may not be able to accomplish that year. We already talked about communication, that's really important. One more thing on boards. So if you have a dysfunctional board where you're not agreeing, or there's personality conflicts on the board, something you may want to consider, and I think Ruby just came to a lunch seminar that I talked a little bit about this, is have your board take a personality test for each of the members so that everybody understands what their personality types are, so you can better understand why that person behaves the way that they do. This is only for like highly dysfunctional boards, but because sometimes the boards are fighting so much between themselves that they can't get anything done. And sometimes what you need to do is actually have an intervention where a third party comes in and explains, this is why your board isn't functioning well, and what can we do that focuses on our strengths, and so that we can all work together to accomplish the common goal. Because we're all here because we love our association, we love where we live, we want it to be the best place possible, but we all have different personalities, and we all have different skill sets that we bring. And one way to do that, there's this DISC personality test. I learned about this when I went back and got a master's in business. And it really does make life so much easier when you understand this. There's 4 personality types, and I'm the S personality, which is I get along with everybody, but my husband's a D, and those people are very direct, dominant, and sometimes the Ds gravitate towards the president position, kind of like what I told you about my board last year, where we had a D running it, and it kind of, everybody was upset because he would, say some things that were a little bit, people kind of rub people the wrong way. And so if you can best understand different personality types, then you can find a way to put the puzzle together so that you can all work together. Just a suggestion. Make sure that you are following your governing documents. If you have an operations manual, I think that's an excellent idea. Also as like kind of a 411 for new board members when they come in so that they know, what the contracts are for the association, et cetera. Make sure you're following the law, the open meeting law. Make sure you're having an annual meeting every year. Make sure that you're taking minutes. There's different types of leadership styles. Every style, has its positives and its negatives. Just try to recognize that whoever is leading your association understand where they're coming from. And we have a cheat sheet also on the DISC model on our website right now if anybody's interested in learning more information about that. I'm going to just do one more slide and then I'll do questions. Okay, so just a couple closing points first. Thank you for coming today. Second, over the summertime is a great time to do CC&R revisions. So one thing that we're offering is, and we have been doing this now for a couple months, is that if your board wants to have a free CC&R review done, we'll do 15-minute complimentary review. We'll tell you quickly what we think needs to be changed, how you can change it, what the procedure is. That's a great summer project if anybody's wanting to work on that over the summertime. We also have a monthly memo that we send out with just important information on new legislation, cases. We only send it once a month. And you can sign up for the monthly memo on our webpage. We have our first Friday free call-in. Has anybody in the room taken advantage of this? I know you have. Okay, good. So the first Friday of every month between 9 a.m. and 10 a.m., so this one's going to be coming up here in 2 days, we let anybody who is currently serving as a board member call our office, and you can ask one question for free. And we get over 100 calls. We return every call that comes in. It's just a nice little service thing that we do for our industry to help board members, because sometimes your boards don't want to pay for a legal opinion, so we can give you a quick verbal opinion on the phone. And then, of course, we're really active on Facebook, Twitter, and we have a very active website with all of our cheat sheets. And we're rolling out a bunch of new videos now called 3 Minutes with Mulcahy, which take a subject, and we put a video out in 3 minutes just to help you better understand a subject. Okay? Okay, thanks. If anybody has any questions, you can email me at my office, and I'll respond before Friday close of business, okay, at no charge. So have a nice weekend, everybody.